supervisory time if we're not taking them away from their job. If your request requires that they go to the off-site storage facility and sit there with you while you thumb through boxes of documents, there's justification. More likely, they just make room for you in their office while you inspect or make your own copies. There's no justification because we're not taking them away from their job. Inspection. I always tell people this. If it's a lot of records and you're not sure exactly what you're looking for, ask to inspect them and make copies of only those records you want copied. You might have 1,000 pages and there's only 6 that are relevant to what you're working on. Ask to inspect. There could still be a supervisory charge. There could be a charge for the time it takes to review the records for exempt information. But it's going to be far less than the copying charges. And if they have to make a copy of a page in order to redact exempt information for you to inspect, they can't charge you for that copy. They can only charge you for the copy you walk out with. Everyone has the right to inspect public records in some meaningful form. An agency must provide a copy of the record in the format requested if the record is maintained in that form. You have a copy of the budget in Excel. I make a request for its native electronic format. I get it in Excel. You can't make me take a PDF. A PDF is nothing more than an electronic photocopy. It does not have the metadata. And I know President Obama said, don't worry, the NSA only has access to the metadata. The metadata is what we're worried about. Don't ask for electronic form. You ask for electronic form, they can give you a PDF. Native electronic format. Yes, ma'am.
You just sort of answered my question, but it was along the lines of metadata, because I am a lawyer and I respond to discovery requests in lawsuits, and we get native requests, but if you don't specify the metadata that goes along with that, you can strip out some of the metadata.
Only if there's an exemption for it.
Right, but my point is if you have the email, and let's say there's an email, there's 4 or 5 attachments, how do you know when you get the record that you got all of the attachments?
You don't.
That's where I was going with that.
I mean, it's the same way if you make a public records request, you don't know always that you got. So you read, for one thing. This is what happened with this Steve Andrews case up in Tallahassee against the governor. He made a public records request. He got like 1,000 and some emails, and he made his poor wife read them all. And in reading them, they realized that they were referencing emails that weren't in that group. When I was making my public records requests early in the Scott administration, and again, I sound like I'm picking on him, but he's in a lot of public records trouble right now. I made these public records requests for the email correspondence, and I was told that his chief of staff did not email. But we're being told that now, that the chief of staff and the governor do not text or email each other. But in this case, I was told that the different chief of staff didn't email, and one time I think I got 3 emails, and that's the only time I ever got emails from that particular person. Well, in reading the emails I was receiving from other staffers, I was finding all sorts of emails sent by the chief of staff that were not given to me when I made a public records request for the chief of staff's emails. So you got to read them. And then you can go and ask for, well, you can ask for an in-camera inspection. And you can say including all attachments. I wouldn't say all metadata because the metadata is part of the record and would have to be extracted from the record in its native electronic format. The metadata tells you, like if you get an email in PST format, it tells you who the blind copies are. You don't see that if you get a paper copy or a PDF. If you get it in a Word document, it tells you what was changed and when it was changed. So metadata can be important. And I always get the, well, if I give you my budget in a PDF, you can change it. So, I just read a report about a reporter up in New England somewhere who got a city's budget or a county budget, And she manipulated it and figured out a way to save him $1.7 million. What I do with it is none of your business. Yeah, I could change it, but you've got the public record. You know what it's supposed to say. And we had a weird case down in Naples where the airport authority put a document on its website, and a citizens watch organization took the document off the website and reprinted it. And in translating it, it screwed up some of the characters. And the airport authority went to the sheriff, and the sheriff brought charges against the citizen who published a newsletter claiming falsification of a public record. He didn't falsify a public record. He made a copy of a public record. And he didn't falsify it. It just messed up a couple of little characters. It was a very bizarre case. And, I mean, the sheriff brought the charges, but it took a while. Right. All records are presumed open. Only the legislature can create exemptions. Even the courts can't judicially create an exemption. They can interpret the exemption. They can't create. Agencies have the burden of proving to me that the asserted exemption applies. And they have to put I don't have to put my request in writing, but they're required to put their denial of my request in writing if I ask them to. And they must explain, and I love this phrase, with particularity, their reasoning that the exemption asserted applies to the record in question. Not, this was one of my favorite requests. You've made this public records request, and these 3 exemptions apply. We agree it's kind of dubious, they may or may not apply, but try these 3. No, with particularity. If a record contains both exempt and non-exempt information, the custodial agency must redact that which is exempt and provide access to the remainder. This is the problem. They can pass those fees on to us. Even though there is commercially available redaction software, agencies are not required to use it. There's no incentive. The U.S. Department of State receives 5,000 public records requests a week. They have been using commercially available redaction software since at least 1991. Easy peasy. But there's no incentive because they can pass these costs on to us. This is important. Information that is exempt from public disclosure is different from information that is confidential and exempt. If it's exempt, the agency, the custodial agency, has the discretion of releasing it. We run into this most often when we have a law enforcement officer arrested for a crime. Law enforcement officer is arrested for lewd and lascivious. Orange County Sheriff does not want to give us his mugshot. It's exempt. Law enforcement officers' photographs are exempt. If it was confidential and exempt, like the name of a rape victim, it cannot be released except as specified in the statute. But if it's exempt, there is discretion on the part of the custodial agency. Yes, ma'am?
Could there be repercussions if a law enforcement agent comes in and makes a records request and represents themselves as a law enforcement agent, and then only after the request is fulfilled you find out they were getting it for personal reasons?
It depends on whether they're trying to get access to exempt or confidential and exempt information. Or they're doing something like running a tag number because they don't like the way you look. It would depend. And there is case law actually involving law enforcement. This was before autopsy videos were exempt from public disclosure, but some law enforcement officers were having a party, and they took a couple of autopsy videos to the party as entertainment, and they were sued by it's a public record, we can't be liable under tort law. And the court said, well, had there been a public records request for it, you're right, there's no public records request made, you just took these. So yes, you can. So the rule there is you generally won't be liable for releasing information pursuant to a public records request. But some of the confidential and exempt exceptions, like the identity of persons involved in car crash, if you intentionally release that information to someone not authorized to receive it, it's a third-degree felony. So that's where you would say, give me your identity, make sure people make a public record. And if they want, I mean, this is important because if it's confidential and exempt, a law enforcement officer is not allowed the identity of the people involved in the car crash. So to give it to a law enforcement officer would be a violation, and that officer is not subject to a third-degree felony, you, the custodian. Federal law. We could talk about HIPAA from now until midnight. Access to records subject to disclosure under state law can be denied pursuant to federal law only if there is a specific conflict and a specific statutory exemption under federal law. Usually what the legislature does in every case I'm aware of, the state legislature will create an exemption identical to the exemption in federal law. This is true of FERPA, Student Privacy Protection Act, for student identification, identifying information in the student academic record. HIPAA, the Driver's Privacy Protection Act. HIPAA is the exception because there's no real exemption in HIPAA. It just prohibits the release of personal identifying information, personal health records. HIPAA applies to healthcare providers only. It must be a covered agency. A sheriff is not a healthcare provider. And the fact that they dispense aspirin to inmates does not make them a healthcare provider. Copyrighted material, the fact that a public record has been copyrighted does not mean I can't have access, and it does not mean I can't have a copy. Copyright law does not prohibit the copying of a copyrighted document. You've been in the libraries, you go into the copy room, warning the material you're about to copy could be protected by federal copyright law. You can still copy it. You just can't appropriate it. You can't take an article that my husband wrote for Harper's Magazine, put your name on it, and sell it to Atlantic Monthly. That would be a violation of copyright law. But you can certainly copy. And agencies receive copyrighted material all the time. I still get a copy. Now, agencies themselves cannot copyright a document unless they have specific statutory authority, and it's very rare. Universities are the major exception. They have all sorts of intellectual property. So, violation of the public records. Suspension or removal from office. Intentional violations are first-degree misdemeanors punishable by a fine up to $1,000 and a jail term not exceeding 1 year. Ironically, the only person to ever go to jail for an intentional violation of the public records law was from this county. As full board member. Unintentional violations are non-criminal infractions punishable by a fine of up to $500 and attorney's fees and court costs, regardless of whether it's intentional or not. The NCAA case, which was a purely public record lawsuit, $365,000 in attorney's fees. Okay, that's my 800 number and my email address. We have an open government mediation program in the Attorney General's office run by Pat Gleason. That's her direct telephone number and her email address. I would suggest you call us first. And if we think you need Pat's help, I will refer you to Pat. But you can always call us. Did you have a question over here?
I just had a quick question. About medical information, I know like 2.4 doesn't specifically specify, like it talks more like about Baker Act and mental health cases. So is there any statute that references medical information? Because I know it's kind of, we're not really
As it
sure.
applies to court records,
Yeah.
there are exemptions, there are a lot of exemptions in state law for medical records. But I think it's in 119, and I'm forgetting the citation, might be 1.4, might be 1.3. There's a list of all chapter 119 exemptions that apply to medical records. I mean, excuse me, that apply to court records. So it's not in that list, it doesn't apply. You can, and this is part of the problem we've been having with court records, they were putting all this stuff online, and they weren't redacting exempt information. So the Supreme Court ordered a moratorium, they had to take everything down, and now they're putting it all back up.
Yeah.
But there's a tiered system of access. Non-parties only get limited access. Parties and their attorneys get greater right of access, and oddly, members of the Florida bar get more access to the public, even though we don't have anything to do with the case. I mean, I'm a member of the bar.
Yeah.
I've never litigated a case in my life. I've been in the courtroom once. And yet, I have a greater right of access than a reporter. Doesn't make any sense to me.
Excuse me,
Uh-huh.
I'm actually really familiar with the matrix that you're talking about. The,
Yeah, I'm familiar with the
Yeah, the attorneys only get a greater right of access in their own cases.
Well, that's not true in specifically in some cases, because I wrote a letter to the chief judge, or excuse me, to the Supreme Court, asking that they give us all the same right of access. And I do have the matrix, and this might have changed since I wrote the letter. Doesn't make any sense. I just don't want a greater right of access because I'm a member of the bar. I should have the same.
Right now, it's that attorneys get greater right of access if there's their own case, and then if it's not their own case, they get the exact same as the
That's what it should be.
subscriber one. So
That's what it
that's how the
should be.
matrix
Everybody
is.
should have the same right of access, except the attorneys and the parties. And so I'm honestly, if it's not in chapter 119, and it's not rule 2.420,
Yeah, it's like I said, 2.4 they only specify like Baker Act and mental health.
Yeah.
And that's kind of.
I think, if I'm not mistaken, I think rule 2.420 mirrors chapter 1, because I had the joy of going into all 1,100 exemptions and trying to identify which exemptions apply to court records. It was not fun. Yes, ma'am.
What was the section that dealt with ongoing investigation that you mentioned earlier?
Criminal investigations, it's the statutory definition of what is active criminal investigative information. Is in 119.07, now, excuse me, 119.011, parentheses, 3. And then 3C says the following is not active criminal investigative information. If you think about it, that exemption applies to active criminal investigative information. An incident report, a 911, triggers the investigation.
So that should always be available.
The name, there are some exceptions in there, like the name of a rape victim.
But
But-
if it's not nothing like that, there, and they redact the name of the victim, it's not a rape, it's.
They have to
something else.
provide you with the
There's
exact
no reason to
statutory.
redact.
Right. If it's a breaking and entering, there's no, sexual battery, then the name of the victim is subject to the story. Okay, we're gonna come back here at 1:15. There are gonna be 2 attorneys from Thomas and Cicero, which is a big media firm in the Basin Tampa, they represent. Okay, so I'm gonna let these 2 people, like I say, introduce themselves, and then we'll open it up to questions from you. Mark's agreed to talk about divorce law, family law, what else?
Dog bites,
Adoption,
yeah.
anything you want to talk
Football,
about.
whatever you want.
And we don't have internet access, so you're not going to be able to see all my niece's 102 tattoos. I'm sorry. But we'll get started, let them introduce themselves, and then we'll open it up to questions.
Okay, well, my name is Mark Paramanica, associate at Thomas and Cicero down in Tampa. We are a law firm that practices a large part of media communications law, So we'll just kind of keep it open and organic, and wherever you want to take it, we'll go. I guess the only caveat would be, what we're talking about here today. We're going to talk generally. We're not here to give you specific legal advice for your situation, but we can certainly, like I said, talk generally about the law and the balance. So I'll let my colleague Sadie.
Hey, I'm Sadie Craig. I'm also an attorney at Thompson Cicero in Tampa. We love our media law practice over there. My background before law school was print journalism for the Associated Press and Kansas City Star and several other smaller papers. So if you have interest in media law or public records, we're here to help.
As I said, we can ask you media law, First Amendment. I was telling them in Pensacola last week, we had a great discussion. The woman was a documentary filmmaker. And so we had a big discussion, a couple of bloggers in the audience then too, about what you can record and what you can't record. Just anything you have related to open government. We see some trends, and we can start talking that way, and if you have questions that you want answered. One of the issues that we talked about in the morning was the cost of access to records and how that seems to be, we had the Commission on Open Government Reform, we did public hearings all over the state, and one of the investigative reporters said, I always thought that when we got more and more records, on computers and there are all these electronic formats, it would be cheaper and easier to provide access to obtain public records, and instead it's more difficult and cost prohibitive. So those are some of the issues we're dealing with.
First question.
Excuse me?
First question, do you mind being recorded?
No, that's fine.
Okay.
The emails, we have a lot of, nobody, speaking of my niece, they don't email, they don't phone, they don't return a call. It's text messaging. It's all text messaging now. And more government officials and employees are using text messages and personal communication devices to communicate with one another. Those communications are public records. And they have to be treated as though they're public records, which means they have to be retained and maintained according to law. We have a right of access to them. And it is harder and harder and harder to get access to those kinds of communications because they're claiming they got to review them all. Or you make a public records request for the county and you've got 16 commissioners all using their personal devices. And they have to go to each one of those commissioners. We've got a lot of issues in court right now. I was telling Jessica at lunch, the First Amendment Foundation, we're but we're involved in more lawsuits than we've ever been. We join usually as amicus, or we file a friend of the court brief because we have very limited resources. But one of the most frightening issues that I think is going on in the courts right now, again, involves Governor Scott. The attorney, Steve Andrews, who has a land dispute with the governor, made a public records request for all correspondence sent or received by 5 or 6 or 10 or 30 staffers related to this land dispute. The governor's response was that every employee is the custodian of his or her own records. This is problematic for a couple of reasons. One, as a requester, you have to then make, instead of making one public records request to the executive officer or governor, you have to make 10 or 20 or 30 public records requests to each employee. Those employees may or may not still be working for the executive officer or governor. You have to find out who they are. How do you know who was involved in that decision over, high-speed rail? You don't. And the governor's office is not required to tell you. So you've got to figure out which employees you should be making those individual public records requests to. So it's harder for us to request them. But think about the liability that each employee will now have. If I have to make my public records request directly to the employee, and the employee is the custodian of those records, and the employee doesn't comply, I sue the employee, not the executive officer. I sue the employee, who will now be responsible for paying my attorney's fees and court costs if I win. we talked about how expensive that can be. So the liability that the governor's policy is placing on his employees is stunning. And it was interesting when this came up in court, A.G. Bondi and the Secretary of State are both parties to this, also parties to this lawsuit that Mr. Andrews has brought. And the attorneys for the Department of State and for the AG immediately stood up and said, we don't subscribe to that. That's not our policy. So we'll see how this is going to play out, but it's very frightening both for the requesters and for the employees who work for the government, or for the work for the state, because this would be the policy.
Well, and I think it's getting more difficult as people rely on personal messaging, private emails, text messages. It's harder to have government oversight that way.
Right.
I mean, and they really shouldn't be sending emails from their personal email accounts to do public business. I mean, just as a practical matter, that probably shouldn't be happening. But it's allowed, and so now as public records requesters, it's much harder to keep track of the records themselves.
Well, and this is what I always recommend, is that if you work for government, and you say you're sick, or your daughter's sick, and you have to work from home, and you have to work from your personal email account, just CC yourself at your .gov account. That way, it goes through the government server, and you're not worried about Mark here going to court and getting an order from the court making you turn your personal computer over to the court for an in-camera inspection. That's right. Just, and I've learned, I'm not great on text messaging, but I've learned that if I'm sending a text, I can include my email address in the to section, and it will come into my email. That's a great way if you're a government employee and you're sending a text message. You're late for work and you've got to get, there's a meeting and you've got to get certain information to somebody. You send them a text, include your .gov email address, and it will go through the server. It's not that hard.
And I think that gets to the training and policy issues that are left.
Right.
Agencies, because people are just doing these things and then they're playing catch up later on with the actual request that implicates these types of communications. So having good policies and training in place and mandating that would be helpful, and of course it would also dispel any type of innocent infringer type argument that they just didn't know they have to be doing these things. So it's about government kind of getting ahead of these issues too, and being proactive about it.
Right. And which, as we talked about, there's been no incentives. Orange County, you got all wrapped up in TextGate. And as a result, it was pretty interesting, they did get software that automatically tracks and indexes every text message sent or received. Doesn't matter who owns the phone, it doesn't matter which provider they're using. And Dave, I think I was telling you earlier, Dave Dameron, who was the reporter who was covering that, said it had taken weeks and sometimes months to get text messages. They installed the software, and then it was a question really of minutes, because they can search. And there are, for every technological problem, there's a technological solution, but there's no incentive for government to use those.
And I think, we certainly operate in a premise that our public records that deal with public business and in Florida, we have some good decisions on that, but it's not the same everywhere. I didn't mention, but I spent 3 years at the Reports Committee for Freedom of the Press, dealing with our open government initiatives and the Freedom of Information Office. And we were involved in a case in Colorado as an amicus party where the governor at the time was using his personal cell phone for private and public business, and freely admitted that. And the Denver Post had made a request to get access to his cell phone bills. You can have call logs on there. And they said, we only want, we'll give you discretion to determine what was a personal call, what was a public call, and you can black out all your personal calls. We just want to see the log that relates to your public activities. They wouldn't give it up, said it's a private record, it's a cell phone bill that goes to my house, and I deal with it there. Denver Post sued, and it made it up to the Colorado Supreme Court, and ultimately what the case turned on was what the definition of a public record was in Colorado. And the way, I don't know if I'm getting this right this many years ago, but I think the way it was defined was it was made, terms and ultimately concluded that based on these facts, it's just not public record. And was very strong in suggesting that we see this as a problem and that this is a giant loophole, but your relief is not with the court, your relief is to go to the legislature and get the law changed because the definition of public record just hasn't caught up with how we communicate using modern technology, how our private and public lives can blend. So often it's not just a matter of the agencies being behind, but it's a matter of the actual statutory law catching up with changing times.
Did you have a question?
Yeah, it's talking about messages or just personal correspondence, like on your personal device. Is that all correspondence that relates to like city business, or is it those that have a stipend that are like allowed to use it, or is it just everything?
Anything that meets the definition of the record. Remember, the key phrase was anything intended to perpetuate, communicate, or formalize knowledge having to do with public business, regardless of physical form or business or means of transmission. So anything, even if that, again, I'm paying, it's my phone, it doesn't matter. Think about it, because then nobody would ever have a city-issued cell phone. It was one of the arguments we were talking about earlier. We had a case down in Highlands County, and a public records request had been made, and the county argued that the document in question was not a public record because it was written in pencil. Nobody would use a computer, nobody would use a pen, because we could avoid the public records law. The same thing, it was sent to my home. Well, nobody had an office then. Anything intended to perpetuate, communicate, or formalize knowledge having to do with public business is a public record. Doesn't matter who's paying for that phone, doesn't matter if it's a private email account or not. But no, I was also going to say there's a question when a record contains the cell phone record, it reminded me of this. I got a call from a city clerk a few years ago, and she was hysterical because she had gotten a public records request for all email correspondence about a particular issue. And she had, 3 or 4 employees who were working on this issue together. And in reviewing the records, she realized that 2 of those 3 employees had been very nasty and very snarky about the third one. It was very personal. They were talking about her personal life and her daughter and all this other stuff. And she said, and it's all contained in a public record. There's no question that email is a public record. But can I redact all the snarky gossip? No, there's not a snarky gossip exemption. If it's all wrapped up, you can only redact that which is exempt, and you have to provide access to the remainder.
I think I know the answer to it, but I'm interested in Barbara interested in your opinions on redactions that aren't, for example, in this Dropbox case that we're dealing with is IP addresses and who the users are who have access to the documents is being redacted, and we're having to pay for that, for all of that to be redacted, and it doesn't seem like it fits into the definitions under this thing being allowable for redaction. So how would you guys deal with that?
Have they cited their restrictions based on redaction?
I think terrorism was
That was me. They did say security. They cited a couple of exemptions, and in citing the exemptions said these probably don't apply. And I read them, and they don't apply. But they said they're going to fight them because they think providing access to an IP address somehow is a security issue.
Yeah. Well, we had a case, it was Chandler versus the city of Sanford, where our client was basically trying to get George Zimmerman's email address, and the city of Sanford redacted it, and they said that that was just dangerous, that it could lead to some kind of harassment because of the active criminal case going on. And that went all the way up to the 5th DCA, and the judges on the 5th called it the what's going on exemption, and they're just kind of thinking in this context, we don't want to hand over this information, but we don't have an exact exemption that applies. And we want that because you have to have an exemption that precisely fits your facts. They're not broadly construed, they're narrowly construed.
Yeah, and I think the 2 main areas where you see that are security-related issues, or what they could tend to be security-related issues, or that circumvention of possible Stacy's right. You always have to remember, it's their burden to justify the exemption and put forth the specific reasons why they're claiming that the record is exempt. And, you know, it's sort of your duty and your lawyer's duties, if it comes to your lawyers, to really give that a thorough examination and see if that really fits within the exemption. And some of those, like the George Zimmerman email address, I mean, at some point it just kind of, you know, strains logic to say, I can conceive of some imaginable way, some set of circumstances where this could, you know, result in some negative harm out in the universe of all possibilities. But in reality, you know, this really isn't a security threat. And I think, you know, those are the types of ways you have to approach that. Look at other instances where similar records have been released, you know, their circumstances, and, you know, nothing wrong happened here. A lot of times, especially with things like building plans or, you know, locations of landmarks, you know, a lot of that same stuff is available on the internet in other forms. And you could put all that stuff together if you wanted to. It's out there in literature and all that. I mean, you see this at the federal government level all the time. You know, it's sort of mosaic theory. Well, they get this piece of information from us and this piece from over there, and you know, they've got our entire security plan. You know, I think sometimes some courts are, especially some federal courts, are a little more willing to hear those types of arguments, but again, when we're talking about a singular piece of information, you really have to keep it in context and try and make the argument that this is just a ridiculous sort of sky is falling type reaction.
We had it was a number of years ago, I don't know if you were before that at the time, but there was a hysteria over the fact that grandparents of a kid who went to school, I think it was in Marion County, I'm not positive, it's in Central Florida. They were U.S. military and they were in Germany. And they were doing something and found the blueprints of the granddaughter's school online. And they completely freaked out. This was shortly after 9/11. They were sure Al-Qaeda was coming to bomb the school. And there was total hysteria because the blueprints and schematic drawings of publicly owned buildings are exempt from public disclosure. There is an exemption for the Chapter 119 that was enacted right after 9/11. And total hysteria. Well, it turns out the school had put the drawing, the schematic drawing online so that new parents could help their kids find the classrooms. So again, we were talking about this earlier. You've got to think about what information you're putting online about yourself. There is there's a rate my lawyer, a rate my cop, a rate my teacher, a rate my dentist, a rate my doctor.com website. Any profession there is a website. And we had a case in Tallahassee where a woman had an altercation with a law enforcement officer. She was dissatisfied with the way TPD handled that. So she went to ratemycop.com. She put the officer's name, her home address, her date of birth, her social security number, the names of her children, the birth date, the dates of birth of her children, and where her children went to school on ratemycop.com. Willie Meggs, the state attorney, brought charges against her for threatening a police officer. They got to court and the judge dismissed the case because every piece of information that she had put on ratemycop.com she got from the internet. All of this stuff is on the internet. You have to stop and think about what you put up. You know, we're screaming about privacy. Oh, what is Facebook but a total invasion? But you choose to participate, so you got to think about it. Yes, ma'am.
I have a question about working at DCF.
She's the one.
Yes, sorry. So I know there's a lot of exemptions, confidentiality, makes sense. But yesterday, actually, I was working on a story about the death of a 3-month-old, very little detail. And I had to name the victim, and name the parents, and I wanted to see if they had a history or a case file with DCF. The lady press officer said that ongoing investigation, she gave me like a long-winded answer about whatever, for gathering information, but basically no information. So,
DCF told you that?
yes,
Did she provide you with a citation?
no. So I'm wondering, what, since authority. It's become a public fact that this child has died and parents' names are out there. So if I ask, and I mean, she couldn't even confirm, like, if she didn't say whether or not they had even had any contact ever with the family, she couldn't confirm that. So I'm just wondering, under the law, what limits are there in terms of dealing with stuff like that with DCF? What information could she have given to me? Or was she totally in the right?
So this isn't specific to DCF, but just as a preliminary starting point, any records that predate a criminal investigation, they do not become active criminal investigative information just because the investigation started. So DCF records, they can even hand over the DCF records to the police department, but in DCF's hands, those are still public records. They are not active criminal. So the fact of an investigation happening and it becoming criminal doesn't make those original records exempt. So they need to give you a statutory basis.
Okay.
And DCF is not a law enforcement agency, so the active criminal investigative exemption does not apply to DCF. It only applies to law enforcement.
Well, she did say law enforcement is taking the lead on the investigation, but if they're the
That doesn't matter.
custodians of the record,
Exactly.
and they have it and they can give it to me, and if they don't have it, you can tell me we don't have a case file.
We are dealing with it, and Sadie said this before, exemptions are to be strictly construed and narrowly applied. We all know, because it happened here at the Sentinel, the fight over access to autopsy photos when Dale Earnhardt was killed. The Orlando Sentinel was seeking those autopsy recordings because they had done a series about race car safety. And the NASCAR was the only professional racing association that did not at the time require head restraints. And it was the assertion of the Orlando Sentinel and their long investigative series into this that he probably died because he didn't have a head restraint. So they wanted the autopsy photos. NASCAR and the widow Earnhardt fought tooth and nail. They ran to the legislature. They got an exemption like that. Like that. It was the first bill passed. And signed into law immediately. The exemption applies to medical exams. We had a case recently of a young woman who died in Georgia, and her body was sent to some kind of pathology lab at University of Florida, and they conducted a second autopsy. The newspaper in Georgia has made a public records request for that autopsy report, and the university claimed the autopsy exemption. Autopsy exemption does not apply to the University of Florida. It applies to medical examiners. So the autopsy report in the hands of the University of Florida is a public record subject to disclosure.
And I think that raises a good point, when you do get, and you should get a cited exemption, you have to take that exemption and break it down word by word and apply it to the facts of your scenario to see, if it could apply. Because they're strictly construed, that one single fact, the fact that it was at the University of Florida as opposed to the medical examiner's office, is clear on its face. Well, this exemption doesn't apply. So you really have to kind of go through the exemption in the exacting detail, because that's, frankly, that's how we attack these exemptions very often. It's written in a very specific way. It's strictly construed, and sorry, this scenario just doesn't fit those facts, and you have to release it.
And DCF can't claim active criminal investigation. I don't know whether there's an exemption, because there are, remember, 1,100 exemptions. I don't know that DCF has an exemption for active investigations. They could, but they have to cite the exemption to you. And the law has changed. It used to be that all of the reports regarding children under the care or supervision of DCF were exempt. And they changed the law to say unless the kid dies.
Right, that's why I thought that.
If the kid dies, then the record is a public record subject to disclosure, and the child's identity is public record subject to disclosure.
They do this all the time, even with me and DCF, they're quick to say, this is a public record, just because it,
Right.
like they want to do.
Yeah, well, the law was specifically changed back in the late 90s to address the issue of the death of children. Think of it, the purpose of our public records traditionally is governmental oversight and accountability. How many kids does DCF get to lose before we get to hold them accountable? And we can't hold them accountable if we don't have access to the records. When George Sheldon and I think it was when George was head of PCF, he actually, the law says that the agency, I forget, it throws you into court, make a public records request for something, and the agency has to go to court, prove why they should release it, I forget. But George Sheldon actually went to court to open a record when he was head of PCF, because the law said he couldn't, and he thought he should be able to. So he and the newspaper went to court together to get access to that. Yes, ma'am.
Autopsy records that have been submitted as evidence into court, and we're the court custodian of those records now.
I
And
think
somebody-
they're subject to disclosure once they're entered into evidence.
They are?
I believe they are, because that exemption is, they're in chapter 119, and I think, as I said earlier, I think in rule 2.420, there is a list of all exemptions under 119 that apply to court records. If it's not on that list, it's public
The
records.
court records are in the rules of judicial
Right,
administration.
rule 2.420. But there are some exemptions under chapter 119 that specifically apply to court records, and those are listed out in chapter 119. And I don't believe the autopsy videos are.
Well, they're actual pictures from the medical examiner that's been.
I know, but that it's records held by the medical examiner, not records created by the medical examiner. And we have a huge problem with an exemption that really flew under everybody's radar. I could not get anybody to pay attention to it at the time of it being considered by the legislature. And this is an exemption for all photos and videos that depict the killing of a person. All photos and videos that depict the killing of a person. And the term killing of a person is defined as everything leading up to or following the death of a person. This means that when we have two guards in a private prison stomping to death a prisoner and it's caught on video, that video is exempt from public disclosure. Yep. But once it's introduced into evidence, it becomes a public record.
Can you guys it's just like one of those laws that kind of passed already, what we should expect in this next legislative session? I know there's been talk about new laws that further restrict our access to public records. Are there any?
Well, you know, last year we had a record number, 22 new exemptions created, 14 or 15 exemptions reenacted, 12% of all bills passed last session were new exceptions to our constitutional right of access. That was a record number. The lowest number ever was 5. Well, ever, I shouldn't say ever, because the lowest number is 5 to deal with. It just seems like forever. And that was during Charlie Crist's administration. It's hard to say. We're going to have new legislative leaders. We're going to have new legislators, and it takes me 4 or 5 or 6 years to get them to understand what the Constitution says. And it's going to depend on who's the governor. Because if you don't have a veto threat, the sky's the limit. And I have seen already some draft language, that provision I showed you, 1190701, about contractors being subject to the public records law. I've seen an amendment to that would try to codify the Schwab test. This is a list of factors that the courts used to use in determining whether the public records law applied to a private company. And the courts couldn't figure it out, so now they just do the delegation test. Has there been some delegation of governmental duty or authority? I've already seen something that's terrible, you know. It's just, I don't know. I really don't know. We're not seeing as many bills filed as early as we used to because it's an election year. And so I won't start really, so normally I'm seeing bills in August and September. And there are committee meetings starting in the fall, but I haven't seen, except for that one bill. Last year was a terrible year. It really was. A lot of those exemptions were justified, but some of them were clearly only for the special interests of somebody who couldn't even identify. key issue, sort of the trending stuff, use of the Dropbox, that's relatively new. Using a Dropbox to provide access to public records is not in and of itself a violation of the law. You can use Dropbox, government can, but they need to tell us what documents are in that Dropbox. They need to tell us, to give us access to those Dropbox documents. They have to tell us who's accessing the Dropbox. All of those are records automatically created by Dropbox. We have a right of access to that. So the Dropbox thing, the text messaging, and Mark was talking about the laws, sometimes not keeping up with, but that's, our law was amended back in '95 to deal with electronic access, and that phrase, means of transmission, has been used by the courts to get at virtually every electronically transmitted document. Yes?
For ongoing investigations, could you clarify the rules pertaining to victims' names? Sometimes they'll have like police people tell me, they're doing my next pin or whatever, but I'm just wondering what the law says about that, if they have to hand over like an incident report that they forget the name. Is that legitimate?
It's 119.011(3) says what is not active criminal investigative information. The time, date, and place of the incident, the names of the person charged, the charge itself, if they're charged, the identity of the witnesses, and the identity of the victim, unless it's a sexually based crime, that the identity of the victim will be examined, and then anything required by law or rule to be provided to the defendant.
And even if it's an ongoing investigation,
That is
should
what,
always.
as Sadie said, that incident report, that 911 call triggered the investigation.
Okay.
The investigation wasn't active at the time.
Because I'm referring to this 3-month-old thing again, like.
No, it's if they called 911 or the 911 tape, there will be hands of the agency responding to the emergency. Once they transfer it, it becomes a public record, subject to disclosure, and there's no exemptions. But the name of the victim in an incident report, unless the victim is the victim of a sexual crime, like with the UF football player, then the name of the victim will be exempt. They have got to provide you with the exact statutory.
So you're saying, you said you didn't want a family member to see online the victim's name. At the time, I didn't know how to respond because I didn't have training. But I was like, okay.
No, they have to provide you, if you deal with law enforcement often,
Yeah.
there's a little, and I use this regularly, there's a little book put out by the Attorney General's office called the Law Enforcement Guide to the Public Records Law. Get a copy of it, because it explains at great length the public records law, and it's written specifically for the law enforcement community. It explains exactly what will be subject to disclosure and what won't be.
And I would have it on hand with you when you're dealing with them. And show them in chapter and verse what, entitles you to the record.
What they did was they retyped the incident report into a Word doc, took out the name and sent it to me. Or I should have asked, for the document is national state,
Yep.
and to redact anything that would be exempt, and if it is exempt, give me the reason.
Give me the exact statutory citation and explain with particularity the basis for your conclusion that this exemption applies.
And like Sadie said, if an investigation ensues and they take that incident report dropped in the U.S. Story file, that incident report still stands on its own as a public record, because they want to include the file in transparent status.
On our website, there's a little button that it's actually information prepared by Jim Lake, their law partner, with tips for making public records requests. And it gives you 9 or 10 tips for when you're requesting public records. And there's also tips for dealing with a public records request. If you get a public records request, how to respond. And go download our little app. It's really great because it tells you, I don't remember if there's a sample public records request on the app or not, but there's all this information about how to make a public records request, what the law requires, under Chapter 119, under the close. And if you're in a courtroom and the judge wants to close the proceeding and tells you what to say, it's right there on your phone. It's free download for anybody. And Claire told me you guys were creating an app. And I said, I already got one, it's right here. So just download it and it will help you tremendously. Yes, ma'am.
I know you keep referring back to the sexual victim, but isn't it at the same time if it's a child abuse victim, we don't give out that information?
Right.
The statute said that, so if that's child abuse, and they're not going to give you.
No, the kid's dead.
Oh, that's true.
It's not abusive, the kid is dead.
Well, no, it's not, the kid was abused, but the kid's dead, and the law says that once the kid dies, the records and the identity of the kid are made public.
Even if it's in history.
Even if it's in history, right. Right. So if it's an ongoing abuse, the victim, if it's, and I forget, it says in 119.011, the victim's name is subject to disclosure unless the victim is, it's usually, they're domestic violence, sexual abuse, they're different things. The hotline, the name of the kid, the name of the caller will be exempt from the child abuse hotline. Yeah.
Let's say I get a call for a history class anonymously over the phone. Like, I have some more problems in a couple of days and we'll be done. It's done. In the meantime, someone else requests it. Who's charged? Like, because I've heard like this, if somebody requests something and we charge them, if somebody comes in the very next day and asks for the same exact information, we don't have to charge a second person because we've already done the work. Right? Is that right? So even though this initial person asked for it first, the person who's getting it first technically is the one that should pay.
Correct. And you can't, if you created and saved the document, right? You've gone in and redacted it, you've saved it, you get another request for it, you've already done the work. And this was what Angela Corey was doing in the Zimmerman case. She was redacting the documents, creating a file, and then telling everybody you have 24 hours to pay, give me a cashier's check to get these documents, and she's charging everybody the same. But wait a minute, you've already redacted those documents. How can you charge me for the cost of redaction when you've already redacted them? And she was charging everybody the same $217.29. And she was requiring payment only by cashier's check within 24 hours. I can't get a cashier's check within 24 hours. She got sued by a citizen, and the citizen won. She wouldn't accept cash. And it turns out, actually, she was not allowed to accept cash by the state court administrator or something. She had to go get special permission to be able to accept cash. But she could have taken a personal check or a business check. So she's come around on a lot of things. She used to make a public records request in her office. It used to be you had to go through security. Well, that's all right. You go through the security, right? But then once you went through security, you had to take your driver's license and go over to this person who wrote down your name and address and gave you a little sticker, and then you got to make the public records request. She got sued for that. Now they have a telephone on the outside of security, and you just pick up the phone and say, I want to make a public records request, and somebody comes down to you. They took my nail clippers. Going through security at her office, they took my nail clippers.
And then your travel.
Well, no, they did, and I said, I've been through TSA 100 times with those nail clippers. We're much more strict. They took my car keys. Well, you know I'm a terrorist, right?
I think that raises a point, a lot of, sometimes agencies or, little components of agencies have been doing things in a certain way for 20-some odd years, and that's always been the policy, and they're just getting away with it, and no one's called them out on it. So, if you happen to encounter a situation like that, something just doesn't seem right, they're making some sort of weird demand of you, challenge them on it. And, I always say it's a good idea to have the Sunshine Manual with you, or have that the police law enforcement manual with you, and be ready to challenge them right there. It says right here, I don't need to make this request in writing, or you can't charge me search fees for this type of thing. I just want to look and inspect it right here. Have that, because a lot of people that are tasked with being, responding to your public records request, they're just uninformed as well. And they just know that that's the way my supervisor says I do it, and I follow those rules.
And there's no training requirement in the public records law. I mean, now constitutional officers and elected city officials have to have annual sunshine and ethics training. But that's new. And there's no training required for government employees. So they, say, oh, well, come to, I remember when I was on the commission, I was appointed to the commission on the government reform, and I had to have sunshine and public records training. It took like 15 minutes. I could talk about the sunshine law and the requirements of the sunshine law for 15 hours and not run out of things to say. But, and then we expect them to do their job. There's no requirement in the law.
I have a lot of questions. I think I know a lot of uninformed people. For example, school board, there's a clerk to the school board that I work with. If I ask her for, let's say I want to check up on emails from people, school board members, she's the custodian of the records, right? She's the clerk to the school board. She will refer me to the district spokesperson. Is that okay?
Every person who has custody, if she is the custodian of the records, you could ask the superintendent herself for her emails, correspondence.
But that's like an internal policy with this district, is everything from the media, no spokesperson.
Remember, no artificial barriers, no conditions that restrict our rights.
If we've outsourced our somebody asks for record that needs stores on site, can they be charged for the retrieval fee?
I think we have an attorney general's or a case law, either attorney general, you can only charge fees authorized under law. I mean, and that was, remember we talked about the case where it was Joel Chandler, public record request, it was 1 page long, and the private company had contractual authority to charge $175 an hour. Sorry. I mean, if they want to charge the agency $175, they can, but you can't pass that fee on to the requester because it's not authorized by law.
Yeah, there's no you can't pass that.
And you can't contract away your obligations under the public records.
I guess on the topic of just growing trend, I think we're seeing sort of a permutation of this in terms of access to records that are stored electronically and specifically databases. We dealt with an agency who pays their vendor $140 an hour to manipulate the database to run basic queries and get records. Well, they can't actually charge the public that for access to those records. So the agency may have made that decision as a business decision, and you can make it, but you cannot pass that cost on to the general public. I think agencies are kind of struggling with the database access. Sometimes I've heard people say, if I go into the database and get certain sets of information, that's the creation of a new record. That's not true. It's understandable why someone might think that, but the data, the raw data in the database is the public record, and so you have to be able to have access to it. And whatever barriers the agency puts up to be able to get those, they need to be able to get through those barriers to give you access.
Yeah, and I think to that point, something we know with our firm in public record disputes is, when something is maybe stored off-site or it's on some backup magnetic tape in some format, and they come back and say, oh, it's going to take 38 hours for a tech guy to do this, and it's going to be $200 an hour, and you come back with this ridiculous estimation of what it's going to cost. We found that if there's a tech guy on your end that can talk to their tech guy and find out, they're speaking the same language, and they know how to, say, here's exactly what we want, what type of, storage or system do you use, programming do you use. Well, your guy, especially if you have, you work for a major media company, you have guys that know code on your end. Well, I can write a script that pulls out the stuff we need in 15 minutes, and it'll just go in there and extract exactly what we want. It'll take 20 minutes. You get those people together, that often helps, and it just reduces the frustration of the time and ultimately the cost. So,
Geek to geek.
yeah.
And that's why I said that's one of the things that I learned from one of my geeky friends. Make your public records request for the record in its native electronic format. I might not be able to, I have a woman who works in my office who can't use Word. She can't make a document double space or single space. She doesn't know how. And I'm not that bad, but there are problems. I can't open it. I don't know what this is. But I know I can find somebody who can. And so the native electronic form.
Oh, you can finish talking.
No, that's, I mean, we had talked about that earlier. That I don't want a PDF.
So my question is, let's say that you do have somebody that's querying a database. If it takes them, 5 minutes to write the query, or if you have the query already, but it takes, an hour to run through the database, if the computer actually takes an hour to process it, can they charge you for an hour of processing time, or just?
Well, the law, if it's an extensive use of their resources.
Well, I mean, okay, so their resources, not just the person typing it.
Right, it says extensively, this was written back in 1985. Extensive use of agency resources, whether that's personnel or information technology or both. But the costs have to be reasonable and they have to be based on actual costs incurred. How much does it cost them per minute to run their computers? They can't figure it out. And I can't remember, I know Paul Owens here in this building, and I talked about this once. It's either Orange County or the city of Orlando. I think it's Orange County, but I'm not positive. In their fee schedule, in their public records policy, actually includes a charge for CPU time. They claim they've never imposed it, but I don't know. They can charge, but it's actual cost incurred. We know how much an employee makes. It's the hourly rate, including benefits, and lowest paid person capable of performing the task. We know what they make, but how much does it cost them to run their computers?
I can think of a case last year, I requested data from the EM Stars database. Quoted my price of $120, which, I was asking for 5 years worth of records for the county, so it's not too bad. So, but I asked them if they could just give me a sample period, just show me what it's going to give me before I pay $120 on it. Well, it takes the same amount of work to make that one line, and it doesn't.
And it could.
Give me 5 years, so.
Right, it could. Because if it's going to take them, if it's mostly programming time, it could, if they still have to write the same program. And I suggest people do that. If you want all of the email correspondence and the price is kind of absurd, narrow your request to like a particular time frame. Let me have the last week's worth and let me see what I get from that, and then I may come back and make a second public record. But please don't make 17 public records.
Okay, I was going to suggest that before you make a request, ask for the schema of their database so you know the keys that you can use to access data.
Right. And that's, I'm not a geek, but I will talk to the IT person. This is what I'm looking for. What's it going to take me to get that information?
And if you're still facing a fee estimation that you think is too high, and I apologize, I don't know what you're covering in the morning session, but you can always ask for a breakdown of the costs. How are you arriving at this number? Break it down by service, by employee. And if there was a CPU charge in there, you should see that in there. And oftentimes when you do that, you'll see the number just drop automatically. But then if you do get the breakdown, you can kind of pick it apart. Why is this person charged for doing a review? At $120 an hour. Why is it the supervisor? Why can't the actual custodian or the clerk do this? So there's ways to attack it and to possibly chisel it down.
Yeah.
And I always ask for an estimate, a written estimate of the cost involved. I mean, that's just good form. And if they're going to charge you and ask you to pay in advance, they have to give it to you if you ask them for it. I mean, you can't, there's a woman I'm working with down in Southwest Branches. The city said, pay us a $50 deposit, and then we'll tell you what it's going to cost you to give you public records. What? No.
I was going to ask if there's any lawsuit that would require a government agency to use up-to-date software for retrieving information. I know for...
It's
Okay.
been suggested in a couple of situations, but there's no lawsuit. Even though the law says that they have to design their electronic record-keeping systems with public access in mind. It says that, and it's been the law since 1995. They're not doing it. And there's no incentive. Again, as long as they can pass the cost on to us, there's no incentive. But you can argue a top-ranking official in the state of Florida have a policy that I had to pay the hourly rate of the person whose email I was requesting. So if that staff person was making $140,000 an hour, I had to pay his hourly rate. Why are we wasting their time? They're making $140,000 an hour. Certainly somebody else can pull the emails.
Yeah, and, sometimes when you see those rates, a good way to throw that back is like, wait a minute, you're telling me this person, if we add this up on a 40-hour work week, this guy that's in charge of responding to public records requests makes $276,000 a year? That can't be the case, And then, again, you'll see that number be renegotiated. Well, what do we do for, this
And don't get frustrated by a high fee. Don't stop there. You see, they come back and say, we want $60,000. You start, as Mark says, asking questions. The fee's going to drop. The fee's going to drop. There was a broadcast station that made a public records request for record $60,000. They interviewed me live on TV, $30,000. We kept pushing, we kept pushing, we kept pushing. Turns out they didn't have the records. And they were legally required to create, these were background checks that they were required by law to conduct. They hadn't conducted them. $60,000, you'll go away. So don't get frustrated. Keep asking questions.
And I know we talked about how electronic records and search fees can get astronomical pretty quickly, sometimes the estimated fees at least. But I found that, at least at the federal levels, when you're just asking for, it's 500 pages of documents, ask for them in electronic form, and they have to charge you what it costs to provide them in electronic form, not a per page fee. If you don't ask for an electronic form, they're going to give it to you in paper. It's one, they don't want you to have any, convenience or search capabilities. But two, they can extract a fee out of it. And we had this experience with the Marshal's Office Service when we made a request for records related to their public access to federal mugshots and the policies related to those issues. And the records custodian called me back and said, yeah, we estimated your request is going to cost around $375. And this was when I was at the reports meeting. We didn't want to pay that. We were on topic. So I said, well, what would it cost if we put it in PDF and put it on a disk? And, well, that wouldn't cost anything. Okay, well, let's do that. And, we got it on a disk. So always be mindful of that, especially when you're talking about just, voluminous documents that may not necessarily involve a lot of tech resources. If it can be scanned and put on a PDF, a lot easier to have it